Thank you everyone for coming to our rescheduled Bridging the Technology Gap in Law event. If you guys don't know what Evolve Law is meant to be a catalyst for the escalated adoption of technology and innovation in the legal industry. So we like to do things that get people excited about the next thing in the legal industry. And we do a lot of events, so you can check out our website, evolvelawnow.com. We have a section on events. Two of the events that I want to highlight for you are, we have a really cool event on April 4th for entrepreneurs to be matched with investors and corporate partners, and it's called our Evolve Law Summit. It's our first bigger format event. It's most of the day, and there's lots of one-on-one meetings scheduled, so if you're interested in that, let me know afterwards. And the other thing we're doing is a fellowship program, which is kind of an accelerator for in-house attorneys and legal operations professionals to learn how to use new technologies, and this first one we're doing is on document automation, and it starts in September. So if you have people that you think would like to go through that for a 3-ish month accelerator program and learn everything they need to know about document automation, again, come find me afterwards. So the agenda for today, for those of you who haven't been to this series of events, this is called the Bridging the Gap workshop. So as opposed to our other events, it's meant to be really practical, really hands-on. And the Bridging the Gap is the gap between where we are right now, which is using some technology, but not as much as we could. And there's really great technology out there that isn't, the adoption isn't quite there. So our 3 guests who are experts in their field are going to talk through their particular, they're going to have 3 15-minute workshops on a particular topic. So during that time, feel free to ask questions. It's really hands-on, really interactive. There's 3 topics that we're going to talk through, and then at the end, we'll bring all 3 of them up for questions. So really important that you guys feel engaged. It's not just, watch and listen. It's ask questions. You can ask questions throughout, at the end, whatever you want. But this is a learning experience, and this is how we solve the problem of, being a catalyst for the adoption of more technology and innovation. All right, so we're going to start with Ben from Wolters Kluwer, so I'll give you a little intro. He's got a really great presentation that hopefully we'll be able to see at some point, which is called Having the Answer Without Knowing Why, Practicing Law in the Age of Machine Intelligence. And so Ben is a product line director for tax at Wolters Kluwer, and he's responsible for the overall product management, strategic vision, financial performance, and growth execution of tax products in the legal and business market. So really, really good market, lots of interesting things to say on especially machine intelligence. And so hopefully we'll get your slides up, but come on up and tell us more.
Hi, thank you everybody for coming tonight. It's great to be here. I want to ask all of you if you remember a game from your childhood called Marco Polo. If you remember, someone says Marco, someone else says Polo. Marco. Polo. Marco. Polo. Okay, when you played that game, you were engaging in machine intelligence. It's that answer and response, the feedback loop from where you say Marco and you hear someone say Polo, that you guess more and more accurately where that person is. It's statistically determining the proper location and the correct answer. Actually, when you think about it, Google works very much in the same way. With the linking of websites to other websites, what people click on, it's your question to Google and its response where it's increasingly guessing what the correct answer is. All of this uses something called Bayesian statistics. I won't get into what that is in this presentation. Thank you. You're welcome. You're welcome. But let's ask, what is machine intelligence? First, just definitionally. Because we hear this term used a lot in discussions of technology and the law. It's really a combination of a number of different technologies, including machine learning, and that's the type of feedback loop I was describing with Marco Polo. Natural language parsing, which machines can actually understand the grammar of sentences and break them apart and understand the relation to each other. And natural language understanding, where machines can actually understand the semantics of language and relate it to one another. And using all these technologies together, we can advance the field of law. So how can machine intelligence be used in law to improve its accuracy and efficiency? Why is everybody talking about using this technology in the law today? Well, it really can do what I say a high level 3 things, which then drill down into specific legal subjects. The first one is it increases the likelihood providing an explanation for a question or further questions to help actually get to the answer you're seeking. It increases the likelihood of providing the correct information to help make a decision. And it also increases the likelihood of a correct answer, a legal answer. And that's where the difficulty comes in of using machine intelligence in the law. From my perspective, there are really two key limits of using machine intelligence in the law that we all need to consider as we apply this technology. The first one is that lawyers must be able to understand and explain the answers that they get from this technology. And not all of them can. In fact, very few. The second is the question of the extent that the logic and empathy of legal answers can be quantified with machines. And in fact, if you're following the Senate confirmation of Gorsuch, the candidate for the Supreme Court today, one of his responses was, "I am not an algorithm." And when he said that, he was speaking to just this very subject. So let's discuss even more detail in regard to lawyers. If you look at the Model Rules of Professional Conduct 1.1 and its comments, if you look at one regarding the competency of lawyers, it requires that lawyers investigate the factual and legal elements of a problem, use methods and procedures to meet the standards of competent practitioners. Of course, this is describing what competency is, so it's a bit circular, but it's incumbent upon lawyers to investigate the facts. They must understand what they're doing. And also, recently, the Model Rules have added a requirement to understand the benefits and risks associated with technologies. So before machine learning can be used in a law, lawyers are bound by their ethical obligation to investigate and understand them. But here's the problem. Machine intelligence evokes algorithms. It uses algorithms. It uses Boolean logic. Lawyers use Boolean logic in research services, but it's taken to the nth degree, and it escapes their training. In fact, the training of probably most of the people in this room. It's hard for them to understand the answer. Before machine intelligence, lawyers just dug through books and were able to naturally come upon the answer, and impressed upon it, they were able to track back through and explain how they came to it. But in the age of machine intelligence, taken to its logical extreme, it says whether someone's guilty or not by applying the facts to the law and saying what is the most likely answer. And the question is, could that ever be acceptable? And where is the boundary here in using this technology? We actually have some precedent to look upon here in the use of machine intelligence in the law. If you look back at the early 2000s, there was a case called Zublocki, which was the first time that in a court case, the plaintiff was allowed to use statistics to do some sampling of emails. In subsequent cases since then, we're getting closer and closer to the point where statistics and statistical results are actually going to be accepted by courts as evidence. And that's the point where using machine intelligence to arrive at answers, at what point do we say the machine is right? That's a legal conclusion. So here's some key questions that we have. With the conclusion of machine, will it ever be accepted as legally relevant? How far down this path will we go? Where is the line that's going to be drawn? And how will all this precedent that you see in Zublocki and other cases around e-discovery apply in other areas of law, like contract analysis for compliance purposes? So conclusions. Law firms and legal departments will be pressured to increasingly use these technologies to drive efficiency, especially as one begins to do so, and larger players come into the practice of law and start automating it. Nonetheless, there's a question as to what extent lawyers will be able to use these technologies, and where does it cross their ethical boundary to understand the answer when they're using them. Most critically, if we don't understand these issues and know how to draw an audit path from the answers back to where the machines came up with them, these technologies will be relegated to finding aids. It will not be used to actually increase efficiency through answers. That, or I believe, will wind up with two tiers of law. One tier, which is the current tier, very customized answers from individual lawyers using human knowledge. The second tier is another area of law where we're using machines to drive answers. Less expensive, but more efficient. And the question is, are we going down that path? Thank you.
So we've got about 5 more minutes for questions. So I'll start. What does this look like in 5 years? Where will we be in 5 years?
Well, in 5 years, I actually do believe what I was saying, which is I think we're going to have a divergent path where you're going to see 2 tiers of legal service. One, the very bespoke type of service where humans are involved end to end with customized analysis. And the other, you'll see these technologies increasingly fill in where people can afford that type of human level of analysis and will be using machines more and more. You will see machine learning be applied within large law firms, but more as finding aids. But large law firms are going to increasingly struggle as they learn how to use it and to what extent.
Question?
In your analysis, you kind of went with like a dual setup. You have the high-end, bespoke, kind of customized work, and then you had the machine learning. Do you think that maybe it's the actual truth that the machine learning is actually going to be more accurate more times because of a lack of human error? And does that create an even tougher situation for lawyers who have to kind of justify their results, which is based on sometimes, effective like human error?
I think you're absolutely right, and I completely agree. In fact, we see associates in large law firms using Google to arrive at answers. They're in that very situation where they're then have to track back and understand, why did Google come up with that answer? Why is it showing that as the first result? And so they're placed in very much that same circumstance. They then have to go through and figure out, is this the truth? Is it really the best answer? And how do you defend it, or do you rely upon the machine? And I think you're getting to the exact problem that I'm trying to raise today.
Question. What about intellectual property? I mean, I work for a large law firm, hypothetically speaking, and we developed some really good algorithms to come up with some answers that distinguish us. But in order for the counterparty, they will have to see exactly what we have, why we have come to those conclusions, and there goes my intellectual property.
No, that's a good point. How do you explain the answer without giving that up? I don't know if you can. I mean, given the fact that lawyers have ethical obligations to understand the answer. In fact, they're the final arbiter of the truth. And can you hold that back from them when it's their duty to know? I think it's a challenging problem.
Oh, absolutely.
Yeah.
But perhaps you need to bring more of the IT people into the decision-making process in the law firm.
That's true. So I think the matter is, do you actually prepare the ability to have expert witnesses explain what occurred whenever you do routine, efficient work? And these technologies are often used to drive efficiency and costs down. And how do you do that when you need to have that level of expertise available to explain the answer?
As far as the idea of machine learning, to my understanding, it gets better as it learns more.
It's like Marco Polo. The more you hear Polo, the closer you get to where someone is.
And so it's also coming to my mind as an analogy. You've got the idea of the cook in the kitchen who doesn't have a recipe, but they know from their vast experience that they pull things together and they make their little judgments along the way. And then you have the recipe in the book where it says you put exactly 2 cups of whatever in. And so to the extent of, having the law be there in this very mechanical way is something lost by not having that customizing ability.
I agree with that as well. And what's really interesting in preparing for this, I couldn't help but think of Justinian's Code in the civil law nations, where they really, Justinian tried to come up with a perfect code of law that everyone would follow without variance. And it's really been an almost impossible task. If you try to take those same rules and put them into a machine, is it possible to do the same thing? I don't think so. And that's why I think there is a limit to the use of machine intelligence in the law, because I think eventually it is a matter of empathy, that lawyers and judges aren't algorithms necessarily. They are to some extent, but not necessarily entirely.
You don't want them to stray too far,
Yep.
but...
There's a limit, and there's eventually a human-to-human empathy in the law that can't be entirely codified.
So what are your thoughts on things like Ethereum, where they want to have kind of a digital contract that's backed by like a digital currency, and also
You're describing the blockchain.
yeah, so blockchains were, and also the way that machine learning has been used in chess, where the human plus some computer assistance is better than just the best human or the best computer. Like, how do you? Yeah.
Yeah, so sorry, it's just two different topics. Let me sort of split them up. So we're talking about using the blockchain. That's generally used to automate transactions. And you see IBM doing that with Linux and other solutions. I don't think that's machine learning per se on this topic. It's more just mechanical at this point, but currently could play a role. Regarding the latter solution, I actually see that as what you're describing for large law firms, which is how lawyers will use machine learning to enhance the practice of law, but how do they understand what the machine is doing when they're working with them? And that's where the rub is. But I actually think it is the best solution, is the combination machine and man and woman will be the best answer going forward.
What is the pressure that you see from the user who might use Alexa in 5 or 10 years and ask a question to Alexa first? Go to a law firm, and then when I go to a law firm, I have like 10 possible answers. How you see the pressure from the user to the corporate world to come back with the technology? Because now I want to spend 2 hours talking to you to give the answer and pay you $5,000. Do you see that the people will push the law firm to change?
Well, that's where the bifurcation, the divergence of what I was saying, types of legal services I was describing, where there might be people who would prefer to have legal services from a machine for efficiency and cost purposes. But not all legal problems are going to fit into that domain. I think in 5 years, the foreseeable future, there's going to be a vibrant legal industry, given some of the issues I described today. And so you will see that conflict come up where you see customers that are probably better customers for machine learning, machine intelligence type solutions, and other customers that know that they're better with law firms. And I think you see that already with the fact that people Google answers before they go see a lawyer, and they often walk into an office just like before you go see a doctor. You often know at least a little bit about the subject, even if you aren't necessarily an expert. And sometimes you are just better served with Google itself than going into a practitioner's office.
Could you see an analogy with TurboTax and accountants?
I do, but that's compliance, which is really different than what most lawyers do, forms-based. Lawyers are often involved in planning or litigation. And so I think it's interesting to see what's been done there. And I was having a conversation earlier that one of the things we see in the future where you really see these technologies that will be employed in the service of law is if you allow non-attorneys to participate in the business of law. And when they come in and start to drive efficiencies, as we've seen in other places like the United Kingdom or Australia, that's when you'll see these technologies used more and more, and these issues come up again and again.
So, what are your thoughts about like when there's a conflict where the machine intelligence reduces billable hours?
It's a business model problem, and it's one that law firms are already facing. I think that the law, quite frankly, could be infinitely complex if we want it to be. And using machines, we can actually use it for the benefit to create better answers and allow lawyers to do more analysis than they would otherwise be able to do. I don't know if that business model actually will go away, and I don't think that machine intelligence will necessarily destroy it. Because what I'm saying today is I think there's a barrier to entry for machine intelligence inside the at least high-level practice of law. And so I don't think it's going to completely eradicate that.
Question?
So I think to some extent the highly audited services are more of an issue, right, with a lot of litigation-oriented stuff. But in the world where you're more of a process manager on the transactional side, do you see that we're just going to have, for example, solo lawyers that can do whatever any large law firm can do? Because you see that a lot of the technology that's coming out, whether it's machine learning, whether it's just even like scraping and managing, we're getting rid of docketing clerk, we're getting rid of any kind of document management where, going to the cloud for all that, you don't need a business practice manager? Is it just going to be a setup where you've got kind of empowered process managers? Because, when you, at the end result, when you have a document, when you have anything that's involved in whether it's document production or anything like that, you don't really need an audit trail. You just need to know if this document works the way it's supposed to.
Right.
So do you think maybe it's going to be, like a third branch where it's process managers, where you're effectively a relationship manager with the company?
Yeah, I mean, you have to get into specifics here when discussing this. So when you say a document, in what context?
I mean, I'm thinking just off the top of my head, like anything from not so much the legal memo world where you're going through like litigation oriented stuff, but when you're dealing with the transactional stuff, contracts, bylaws. I mean, I think we're already kind of halfway there, honestly.
We are absolutely halfway there, but even when doing those sorts of things, when putting something into bylaws for a major corporate deal, you still have to understand why that's the proper thing to put in there. And if the lawyer is actually being paid to draft them, they must understand that notion. And even if the machine is telling them that that's what they should do. So again, but I think you're seeing where there is a line. And for lower level work that they don't necessarily want to pay for that level of responsibility, I think the machines will have a large role in producing those sorts of documents. But then there's a new job for someone who understands both the law and what the machine is doing that can be employed on a piecemeal basis when the issues arise. And that person will be very, very valuable.
Last question?
Yes. Following that question, do you think that person is going to build a company that's going to disrupt the market?
That person could disrupt the market, absolutely. Great. Well, thank you so much for coming out tonight. It's been great.
So we're really excited to have Ishan here from Priva. And his conversation is going to be on understanding data security risks when using technology. So Ishan is the Chief Executive Officer of Priva, a software company focused on identifying and managing third-party vendor risks throughout the lifecycle of data sharing practice. So thank you so much.
Thank you. Thanks for coming out today. Just quickly, how many of you work for law firms or are vendors for law firms? Which ones are law firms first? And vendors for law firms? Perfect. Now, half the people don't do anything, so I guess that we're going with that. So, cybersecurity is top of mind. It's a big issue. We hear about it every single day. And data is now being transferred from clients to their vendors. And that's really what I want to focus on today, is how do we make sure that the vendors are properly protecting that data? Because that's important for us. You know, when I started thinking about doing a presentation, this quote came out from the CIO from the chief staff. He said, cyber warfare is like a soccer game with all the fans on the field and nobody's wearing uniforms. Basically just shows how complicated and challenging it is to protect your information today. It's really the Wild West. Everybody's a threat. Doesn't matter if they're inside your organization or they're outside your organization. We really have to be cautious, and we have to treat everybody with the same amount of respect that they could actually compromise our situation. So as, you know, taking the legal perspective, law firms get a lot of data. They're pushing it down to their vendors, and that can be anywhere from your time and billing. I've heard horror stories where a lawyer put into their time and billing software that they were having a lunch with a client to discuss a potential IPO. That means that time and billing software was potentially a threat. If that information got out, we have a significant problem. So the legal industry is moving to a cloud-based environment. It's already there. It's getting worse. The larger law firms have been doing it for quite a while. The smaller law firms are following suit. So everybody's a threat. It doesn't matter if one single vendor gets hacked, then you're only as strong as your weakest link. Lastly, this is really part of the cost of doing business. I'm a vendor, so I always have to fill out a security assessment anytime we get a client. So the customers, the enterprises are demanding the law firms have the right security policies and procedures in place, and one of those is, do you do third-party vendor risk? assessments because they know the data is being flowed from the top down, and it doesn't just stop at the vendor, but we all have products and technologies and solutions that make us operate. So for example, Priva, all of our data is hosted on Amazon. So I fill out a security assessment, and then they ask me, well, have you guys evaluated Amazon? Obviously, if Amazon and Google get hacked, we're all screwed anyway, so that's a whole other project. So what does it mean when you're doing supply chain risk analysis? It's really about going to your next level, who has your data, communicating what your policies and procedures are, and then making sure that they follow or exceeding those minimum thresholds. So once we do a security assessment, you're able to, at the law firm, you're able to identify and quantify, and then you prioritize where your cybersecurity risks are. So we can't capture and we can't solve every problem today. So we want to figure out what's most critical, which vendors are the most critical to us, and then we identify what measures we want to take to mitigate those risks. Everybody's heard Target. It's been told time and time again. The fascinating thing is everybody's heard that it was the HVAC vendor that got hacked, and that's pretty much what everybody knows. What they don't know is it started off with a simple phishing campaign to Fazio Mechanical, where an employee at Fazio Mechanical clicked on a link. The hackers were able to drop malware onto their system through a port to Target. They dropped malware onto the POS system at Target, and 3 months later, they had access to 40 million credit card records and 70 million person identifiable information. The point here is it's the smaller companies that don't have the right policies and procedures. In that example, if Fazio Mechanical would have done a better job of training their employees about what phishing campaigns are, what could be a potential threat, having some sort of product to identify if a certain attachment in an email was a malware, then this could have been potentially avoided. So when I think about the pillars of what you need to look at, there's really 3 things. People, employees, that's obviously the biggest problem, services, and then products. So what employees at the vendor level have access to my data? Have you done background checks of them? Are you continuously monitoring those employees that have access and doing rights management? Services, if you're coming in and you're going to be in my office, who's going to be in my office? When are they going to be there? Why do they need to be there? And then what measures are you taking to make sure that they're not compromising my employees or my product? And then lastly, I talked about earlier, what's making up your product? That's important. It's not third-party risk that's truly the problem. It's fourth and fifth-party risk. I had a really long discussion with some people over at Travelers Insurance, cybersecurity insurance, big problem, and that's their biggest concern. It's not about having it on my database, but it's who else is supporting me. So I want to just sort of talk about best practices, things that the larger law firms are really doing very well today. The smaller law firms are starting to get there. Their clients are requiring it, and I've actually heard a CIO of a top 200 law firm that told me he had to tell a partner that he had to turn down a large client because they couldn't fill out his security assessment properly. That was not the good day for that partner. So what do you want to do? First, you want to identify all the vendors that are in your supply chain. And you really got to expand that out. It's not just having access to data. Our clients are even thinking about janitorial staff. ABM, for example, is walking around your office and they're cleaning up after you leave the office. One document left on a desk is a cybersecurity breach in some form or manner. So expanding that to hardware, software, and services is important. Take all your vendors, put them in different categories. So what's their criticality to your business? So obviously a document management is going to have a lot more potential harm to your organization than a janitorial staff. So categorizing them from tier 1 to tier 4. That allows you to start asking the right questions based off of their risk profile. You may want to ask 100 different policies and procedure questions of your document management. It may only be about 5 to 10 for your janitorial staff. What are your background policies? How are you doing background checks? Are you doing drug tests, etc.? Then scoring those results, that allows you to now, once you've created them into different categories by their tier, now you can actually start comparing the results from all your tier 1 vendors, find out where the best practices are, communicate that to your management team. this is a board level discussion now. It's no longer just, cybersecurity is no longer just an IT function. Once you have those results, taking them and then translating them into your terms and conditions. So if we find out gaps and we feel that there is a critical issue with the cybersecurity policies and procedures of a vendor, we need to put that in the term and contract, give them a time period. If they don't comply within 3 months and then they're in breach of their contract, then you have the ability to make an executive decision whether you want to continue using that vendor or not. The important part is, and I hate saying this because we're vendors, but law firms have the control. They need us. We need them a lot more than they need us. That's generally the rule of thumb. They can always find a different solution, so they're dictating the terms of what they're doing. And then lastly is making sure you're doing this on a regular basis. So automating the reassessment process. It's not just doing it at the time of acquisition of a new product, but it's also doing it on an annual basis, if not more frequent. We see if you find a vendor that is high risk to your business, but you've decided to move forward with them, and you've created terms and conditions that they need to oblige by, then do that as security assessment every 3 months or 6 months, and just making sure that you are maintaining compliance. So we talked about expanding the definition of a supplier. It's no longer just it should include all companies that have access to your network and components. Also your physical security. If you have an outsourced security company, those are people that have access to your offices, and those are things we need to monitor. CCTV is another one that sort of gets missed a lot at law firms. So there's a host of security domains that we want to cover. I'm not going to go through all of these. These are just some of the ones that we think are really important that every law firm should be asking their vendors. It could be ranging from information security to HR security to access control, etc. Change management is an important part. So if we're building a new product and it's on our server, are we separating the life cycle of development versus staging versus production? Again, translating that terms and conditions. So how does your vendor handle the data? Who has access to it? Is that going to be monitored on a regular basis? How often are they changing their policies and procedures and making sure we're doing this on a regular basis? You know, one of the biggest questions that comes up is, I have vendors, it's not in my contract, are they going to answer the security assessment? They may not, it's up to them, but if they don't, then there's probably a risk that they're going to lose the business in the future. But when you do create that new contract, make sure that it is in there, that you're going to do a security assessment, and you have the ability to do it as frequently as you want. Again, doing it one time, doing it annually. Another thing that's important that we're seeing a lot is if you have an issue like a Dyn, where it's an industry material breach, it's in the news, all of a sudden your CEO calls you and says, hey, does this have an impact on us? Now being able to automate and send out a security assessment, 1 or 2 questions to your vendors, finding out if there is any impact to you or your network through that. And then lastly is just doing on-site audits. So once you have the results, most of the time responding as a vendor is self-reporting. So put in the term and condition that you have the right to do an on-site audit and evaluate all their policies and procedures as frequently as you want. So like I said, vendors typically need you more than you need them. Doing it on a regular basis. Third party, fourth party is important. So go ask your vendors if they've done an assessment of their vendors. That's what's happening today, and that's what's driving this process in the legal industry. Banks are at the forefront of doing security assessments of their law firms, and a key question in every single one of those is, so who has access to my data? And that's why this process has really gotten pretty stringent on the law firm, on the legal side, and it's getting worse. And then just doing background checks, making sure your employees are clean. That's important. Doing it on a regular basis. If every single year, you should really make sure you know who has access to your customer data, and doing that on a frequent basis. Set a policy, stick with it, and communicate it to your vendors. That's important. If they are going to be, there are a lot of instances where a vendor may not meet your minimum threshold. That's okay, but pass the risk to the business side. If you tell a business owner that if they want to use a particular vendor and they have they're a big security risk, make that person sign a disclaimer that any breach of that vendor is their financial responsibility. I promise you they will change their tune.
So this to me brings up the question of on-premise versus cloud technology. And to me, what this is kind of saying is that the resistance to move to cloud doesn't really matter. It's about your own policies and procedures. So would you agree with that, or do you still think that there's a higher security risk for cloud versus on-premise?
I mean, I think the security risk is equal. I mean, even if it's on-premise and they're doing updates and they're doing patch updates, so you want to monitor those patch updates to make sure they don't have any sort of security issues in them. And so that's something important. If they are coming and they're sending somebody on site to do any sort of updates to that product, even if it's hosted on your own server, then that's a security breach. So who's coming into my office? What are they coming for? Have you done proper checks on them as well?
On the non-audit but the technology side, is meta tagging used? Is all this, because my thought is if you have super sensitive documents, you're going to want it in only lockdown computers with only, there's only so much you can do, obviously. But are you seeing that people are doing the issues of like meta tagging, using all that can be only used on, say, a set of lockdown computers, something like that?
At the law firm side or the vendor side?
I'm thinking more the sensitive vendors, the document review guys, stuff like that. People are actually dealing with privilege and all this stuff too.
Well, no. So, that's part of the questions you want to ask your vendors. And so, yes, if a vendor says that's how we're managing it, you're going to go through the security assessment process. The vendor's going to communicate, we do hold sensitive information on locked computers, only accessed by these people. Here's the proof that we support, that shows that this is how we're managing it. And then the law firms are going to have the rights to come in and do an on-site audit, though.
I'm thinking more on the technology side, where you use metadata and tagging to actually restrict itself rather than like audit procedures. Is that coming into the world, or is that kind of 2 steps ahead?
I think that's probably 2 steps ahead right now.
So everybody knows there's kind of a dynamic between more security and kind of inefficiency in some way. The more passwords you put in front of people, the more tokens they have to carry around. The more times they have to change their password, it kind of slows them down. So is that involved in if you add 3 more layers of security and it slows down your team by X%, how does that play into your analysis of, or increasing the cost by Y%? That's really what it comes down to.
Yeah, it's there was a great quote from somebody at Morgan Lewis. He said, "It's not the common denominator; it's the least common denominator." He said, if one vendor has 52 character password, that's now his minimum threshold. He's going to tell every one of his vendors to have that. So it is creating inefficiencies. I can't say it's not, but vendors are going to be required to increase their security protocols, and you're not going to be able to pass the cost on that much to them. It really is going to be the cost of doing business. Procurement used to be business efficiency and price, and there's a third pillar as part of that equation, and it's security. And that's just something you have to do.
It's not even a cost to the vendors, it's actually a cost to yourself. You have your own attorneys who are reviewing documents, and they have to do different hoops to log into the system, or change your password every week or whatever. It's your own cost as well, right?
Yeah, but that's being secure is something that you have to do. You want to be as secure as you possibly can.
In many industries, there are generally consortia that develop security standards that apply across that industry. And I was wondering if you've seen that sort of same activity within the legal space, perhaps from the ABA or others, the bar jurisdictions, trying to unify security standards.
Yeah, it's been tried, tested. ABA came out with one. EDRM and Duke Law came out with one last week around the e-discovery space. So it's about 87 questions or so, and that's what they're trying to create the standard and saying, well, if everybody has to just meet these standards, then we're now making it very efficient. I think it's a pipe dream that we're going to get there. The banking industry, the big banks actually have colluded to purposely not ask their vendors the same questions because they actually want you to have to go through the process of answering it and taking time to go and make sure you're meeting each one. versus just saying, great, I did it for Bank of America, I'm good for JP Morgan. And JP Morgan, their security assessments ranges between 300 and 400 questions. Goldman Sachs is 400 plus. Sometimes they're not even full sentences. It's pretty comical. So the goal is that there is standardization. I think it's a little bit of ways away.
Last question?
You gonna follow?
Yeah.
What about government standards? I mean, that's pretty well set. We might just use those.
Yeah, I mean, so the NIST standard is what's driving that. So there's NIST controls, there's the CIS 20 critical controls, HIPAA. I mean, there are standards across the board, but everybody has their own idea of what's relevant. What should I be asking my vendors? And if they, sometimes it's crazy, but sometimes you hear CIOs just say, well, if I just take that guy's information, then I don't look valuable to my company. So he wants to customize it, or she wants to customize it to say, I've done a due diligence and I've evaluated the standards, and this is what I came up with. And they say it's at least proprietary. So, you know, job security is always the best thing.
We'll be back up for more questions at the very end. Thank you so much, Isham. So finally, we've got Catherine Daly from Leap US, and she's going to give a talk on legal practice management. So Katie is the New York small law firm specialist at Leap. She's met with hundreds of small law firm owners in New York and New Jersey to discuss and demonstrate how the implementation of technology can make small law firms more efficient and profitable. So thank you.
Thank you. You can call me Katie, the small law firm specialist for Leap in New York. I started in the New Jersey team, and I have now moved to the World Trade Center, which is very exciting, and only work with small law firms. We focus on the needs of small law firms and solo attorneys, and we've been doing this for over 25 years now. Globally, there's 12,000 small law firms benefiting from Leap every single day. So what I am here to discuss is the 4 main benefits of practice management in small law firms. Now, every firm has a different goal in terms of what they want in order to improve their business. Maybe it's improving client relations, maybe it's just to become more efficient, or as simple as making more money. And a good practice management system should allow you to do all of the above. The first point is one central location for all of your matter and client information. Now, this is very important to a solo or a small practice because you should be able to receive all of the information from your emails, your documents, your forms, templates, maybe it's a PDF, from any device that you're working at any point in time. You have to wear many hats when you are a small law firm. Maybe you're a solo practitioner venturing out on your own, or you just want to start a new law firm. This will allow you to improve your business and work how you want, where you want, and when you want to. Practice management software should include automated forms in all the common areas of law. That includes your document automation. You never want to turn away business because you don't have the legal forms readily available to you, or perhaps you don't know what's necessary to fill out. By having a practice management solution that's already up and running with the legal content in your state and is fully automated, you're able to work a lot more faster than ever before. Email integration is imperative when you are inside or outside of the office. Having everything, an entire chain from your Outlook in one central location, so you no longer have to CC yourself or print it out and put it into a manila folder. Capturing time as you work when you're doing something. So saving a document back and have an automatic time entry prompt. Maybe you're taking a phone call on the run, being able to bill that. Increasing those billables that you maybe would not have access to is important in terms of increasing your revenue. Mobile applications, so being able to access everything from your iPhone or your Android. Last week when we rescheduled because of a snow day, you shouldn't have to trek into the office. You should be able to open up your laptop and work from home, even though you traditionally wouldn't be able to. Simple accounting information, so maybe it's running invoice from the click of a button. Maybe it's capturing a phone call, even having an IOLTA compliant trust account. All of these are very imperative to small law firms because not only are you the attorney, you're the paralegal, and you're the bookkeeper. So you need to be as efficient as possible. Reports to manage your practice. Getting up-to-date information if you're out of the office, seeing what fee earners are up to with the click of a button, or even just general overview, new matters open, new clients retained. All of this is really important to growing the business and making sure that you know how your firm is trending in real time. The benefits of having an integrated solution is that you're going to spend less time on administrative tasks. You're going to increase your billables, which translates to making more money. And you're also going to save time looking for administrative work or maybe just looking for disconnected databases because you have client folders on a server that aren't available to you when you're out of the office. The second point is improving your client service. Nowadays, everything is instantaneous, and your clients expect the same exact thing from you. So if you get a phone call and they ask what the case is up to, they want to know readily available that you have all of the information. And having a solution that allows you to do that is imperative to doing that white glove service that attorneys readily talk about. You're going to increase the quality of your work by having a practice management solution. You're going to build trust and rapport with your clients, because you know exactly what's going on as it's happening. You're going to encourage repeat business from referrals and being trustworthy. You're also going to have a competitive advantage. So if someone else in the law firm industry isn't using a practice management solution and is working slower than you, you are the go-to person. And of course, again, you're going to make more money, which is very nice. The third point is cloud technology. So there's this notion when I go to visit law firms that having all of your information on your iPhone or your laptop is a little intrusive. But I encourage my attorneys to think about the times when they've stayed late at the office because there's just a deadline that they had to meet and they couldn't leave. Or maybe they had to work on a weekend, they couldn't see their children because there's just something that had to be there. Or even like last week, just because you have a snow day doesn't mean you're not working anymore. There's no days off with your clients. And having a cloud technology solution allows you to work from any device, where you choose to, and how you want to do that. And the last point is online marketing. So having a legal website with good optimization is imperative to gaining new clients. When I go to visit attorneys for demonstrations and they don't have a website, I'm immediately off put because I don't know what I'm walking into. It could be the most beautiful, cleanest law firm in the world, but without having that online optimization and I know what I'm walking into, I have no idea as a client. LinkedIn, Twitter, maybe it's your Facebook. These are all potential sources of income if utilized correctly. And having a good website will allow you to do that, and having a practice management software that includes this is also going to cut down those overhead costs. Now the benefits pretty much speak for themselves. You need to be as efficient as possible. If you're doing flat fee work, this of course is going to help you churn out those cases a lot faster. If you need to increase your billables, capturing time that maybe you wouldn't be able to. So taking that phone call on the run and being able to set in a time entry. Reviewing an email from Outlook and hitting a button that saves the time automatically that you are working on it. This stuff increases your revenue. It's going to save you hours, and it's going to allow you to grow your firm. You don't have to increase your headcount. You don't have to worry about location because now you can employ the best of the best no matter of their geographical location. Well, I'll open it up to any questions if you guys have any.
How many customers in the U.S.?
In the U.S., we are on target for veteran 300.
Yeah, that's not current. About 700 users. Each of them roughly 2 or 3 per user on average? About 3 users.
Yeah. 3 users is our average user. We're still relatively new to the United States market. We are based in Australia, completely saturated the market there, moved to the UK, did the same thing in a matter of 2 years, and now we're introducing ourselves to the United States.
Are you related to IntelliJuice? IntelliJuice, is that your parent company?
No.
You know, also
So I was lucky enough to see your product demo and launch a little while ago, and I was very impressed with all the automation and the voice and all the cool stuff that you're adding into it. What's the next thing? Like, what's the future technology that will get people using the product more?
Our newest, well, I'll talk about our newest feature first, is Law Connect. So having a secure document portal, since email is kind of inherent to data breaches, or you don't necessarily know where it's going, having something that's encrypted at all times and clients can upload documents on your side is our newest benefit. We have releases of the product every 3 months, hard releases every 6 months. So we try to be the most competitive, and we get this from our client feedback. So when they come up with a great idea, they say, you can improve on X, Y, and Z, that's where the natural flow comes from.
How do you compete with Office 365?
Compete? We actually don't compete, we integrate. So Leap will talk to not only the Microsoft suite, so Word, Excel, it also integrates with Outlook, which is great for law firms when you're making a form or a contract, let's say. It opens up in Word automatically, and all the information from your practice management system pulls into that document by itself. And of course, since we are integrated with them, you can time save and close it automatically as well.
Cool. Any other questions? All right, so we're going to bring all of our panelists back up. Where we don't need slides, so it's awesome. And we're just going to answer some questions. This is, again, it's supposed to be workshop format, so if there's any questions you have on what they presented, what they didn't talk about, but you think they might have some expertise on, you guys can stand or sit, but we have 2 mics, so you'll have to share them. And I'm going to kick it off with a question, specifically to Ishan, but to the other groups too. How do you compete as an innovator? I don't like to use the word vendor. How do you compete as an innovator that has all of these challenges, right? With the bigger companies who have the infrastructure to do things like be more compliant and have more security. How does an early stage company actually get traction?
Wish I had that answer. Cybersecurity is obviously it's on everybody's mind, so that helps. You know, we're definitely something that's at the forefront of what people are thinking about. And what we're doing, we're replacing an existing process that's very manual. So most companies already do security assessments of vendors. They're doing them using Excel or Word document. So we've automated that solution. Now you can actually compare the results, any supporting documents that the vendors have to provide. It's all done on a single repository. So now you actually have a database of all that information. And that's what we've really stressed to our prospects, is that we can take your existing process, improve it, make it 75% faster. We do the automated reassessment. We're also taking a very cognizant approach of making it easier for the vendors. So the second time you get an assessment from a client, it's already populated with what you provided in the previous experience, so that you're not starting from scratch. So all those different approaches have really just said, we can save you time. We're actually just, honestly, yesterday we just launched our second product, and we're now starting to test that. Law firms have to respond to security assessments that they're getting from their clients. It's, if you ask anybody in the IT department, it's the thing they hate most in life, period. And so we're taking that and we're automating that as well, so they don't have to do that anymore.
Any other thoughts on how startups compete with the bigger folks out there?
Who's the bigger guy?
Yeah.
I'm the bigger guy, but if I were a startup, I'd obviously try and be very specific with a niche need. In fact, when we talk to our customers and we talk to a lot of largest law firms, they talk about a lot of the startups that are coming in these days. It's a different environment than it used to be in legal technology, and so we're doing that to have a very specific message and try to play well within their budgets. And so That's honestly the best advice I can give right there. Is that?
Yeah, no, I mean we're hosting an event. You know, you want to try to do events, get CIOs in a room. So we're hosting an event in a couple weeks where we're bringing a 30-year CIA operative, 4-time station chief, who was Vladimir Putin's direct counterpart in Russia in 1997 when he became head of the FSB. People responded to that email. It was like, I'll come out for that, you know? So doing things that are creative, that they're interested in. Russia's obviously a big problem. So we went and found somebody who can talk about Russia. I'm not going to pitch Priva, but I looked at the attendee list, and there are a whole host of people who I've sent emails to who ignored my, hey, love to take you out to lunch email. But now they said, great, I'll come to this event.
More questions?
I wanted to ask one to Ben, actually. I know that there's a lot of different use cases for machine learning and AI in legal tech, most notably in research, contract review. Other than sort of the big players that are currently doing that, or like the growing players that are doing that, what are some things that you're seeing that are not sort of in the mainstream that are about to do?
Yeah, and especially within contract review, where I see the start is obviously e-discovery. That's where machine learning is first real viable applications at law. Contract review, I think, is the next stage, quite frankly. I don't think it's quite there yet, but I think it's spreading, and we're seeing it get to that point where sort of outside e-discovery, sorry, let's probably differentiate with side contract reviews. Contract review for e-discovery versus contract review for compliance purposes. And so it's compliance purposes that you're really doing that sort of analysis. It's when you get to that next phase where a computer can look at those contracts for compliance purposes or e-discovery and say, well, what's the best contract? And what should I be including in my contract? That's where it takes that language, that technology, and applies it to that next phase. Or what should be in my brief? That's where I see the sort of next beachhead and the use of that technology there. Not to actually provide the answer, as I said, but to help with the lawyer get to the point, they then back through and figure out, make sure that it is actually the best one, but just save them a whole lot of time, at least to get to what they think is the best answer. Right there.
You see, like even a couple of years ago, I remember reading an article on Bloomberg Law that like has that product that you can like search up. You can hover your mouse over any part of a contract you upload into their system, and it tells you what the market is based on their like 100 million contracts that they have.
I know that product well because I worked there at Bloomberg during that time.
That was his former life.
I don't know any big law firm to adopt that, but it seemed great when I heard about it.
Right, so they're using computers to say what is market right there, rather than some other solutions in the marketplace that use editors and humans to say what is market after the manual review. And I found in that circumstance was actually a lot of challenge for lawyers to look at what the computer suggested and accept that as market results versus a human being going through these provisions and assessing it from that perspective. And I think it's actually a great case in point for this, where this challenge in using machine learning for these solutions, because lawyers couldn't understand why the machine was saying what's market. The computer was able to analyze such a vast amount of data, no human being would go through and actually figure it out on their own. And so how do you make that work?
And how do you define what's market? Like a big company, small company, public, private?
Yeah, that's a great question too. And so I think if you can use those technologies to try and break it down the way you're describing, and say the computer has within these parameters that you're describing, shown very specifically that this is what's market, and here's why. The problem is not giving the why with a lot of these solutions. They're just saying that this is what's market. And if they can sort of back that out, I think there's a lot more traction for applying them in these ways that you're describing.
Got probably 2 more questions. Time.
I have a question. It's not so much a product question, it's because you guys are in the front line selling to law firms, mainly, right? Mm-hmm. So my question is, what's the temperature like out there? So you're talking to probably a variety of law firms, from solos and small firms to some of the larger ones. There's a lot of talk about what's happening in the industry. What are you hearing?
Okay. Go for it. So, yeah, personally, in my capacity, I do sell to firms of all sizes. But let me just ask you a question. What more specifically are you saying in regard to adoption of technology, or in regards to their biggest problems they're facing these days?
Sense of where the industry's at.
Okay. Treading water, I would say, in the sense of not rapidly growing, but holding its own all the same, and cautiously optimistic for the future. I think that we're obviously in a political environment where a lot of people anticipate change occurring. I don't think a lot has happened quite yet, at least in the law itself. And so I think that's where I would say it's almost at the point of stasis still, with the tugs and pulls of the things that we're describing to you occurring beneath. I think I was having a conversation with someone earlier, and I see law firms and lawyers in law firms very much doing what they've always done, but underneath them there's a huge amount of change occurring, and really a revolution of thought in how legal work should and could be done. And I think everybody's anticipated this for a long time, but it's true, and you still see this going on with events like this tonight.
I'll add to that. I think somebody talked about it earlier, is with machine learning, billings come down, and clients are demanding more value for the dollar they're paying, and that's where the industry's going, and it's not stopping anytime soon. So hourly billings, whether it's in 12 months or 24 months or 5 years, will be a thing of the past. It's going to be based on value. And I think that has people pretty cautious of spending. So as technology, we're trying to make it better, but you're also seeing some resistance of getting better, because that also compromises somebody's job. I had a former company where we actually did free post-audit audits of clients to find out duplicate billings that went out. The CFOs would say, I don't want you to do it, even though it cost me no money, even though we would find them about $1 million of free cash that went out the door. They say, because then I got to go tell my boss that I spent $1 million last year. That was incorrect. And so people are going to be cautious to adopt technology, because they're going to be at the risk of losing their job. CIOs are overwhelmed, and that's mostly who we talk to. They don't have resources. They're bombarded. I get emails that they're fragment sentences. They're not even complete, just because they have so many things that they're trying to manage right now and implement. I don't deal with smaller law firms at all.
Yeah, mostly from the smaller law firms, a lot of the pushback is, as you said, just with the efficiencies. If you have a firm that is larger, maybe going on the 20 to 25 attorney mark, they kind of bill off of the inefficiencies, and they have support staff there that are doing a lot of the caseload for them. The reason why this does so well in small law firms is because you're knocking down a lot of that administrative time and focusing more on the fee earner work. And I've had demonstrations where you go on site and someone who was a full-timer for 30 years sits you down and says, I feel like this is going to take my job. And the truth is it might, but it's about what you're billing and what you're doing. Customers want the most out of their money.
Okay, we'll give everyone a round of applause. Thank you so much to our awesome panel. 5 minutes, actually. We always end with a Darwin talk. So for those of you who have been to one of our events before, a Darwin talk is a TED-style talk, but because we have the Evolve theme, we call it Darwin Talks, and so it's meant to be exciting, thought-provoking, and Mary was originally going to give this talk, but I'm going to now, so I've changed it up a little bit, and it was on how to select legal technologies. And she was going to talk all about KPIs and really, serious stuff, and I'm going to make it a little less serious. So hopefully it'll be fun and entertaining, so let me know how it goes. But the title of this talk is Be Bionic, how to select legal technology. And for those of you who don't know me, I founded 3 companies, including Evolve Law and Hire & Esquire, so in the legal space, try to be on the cutting edge. By day now, I also am an investor, so I'm always looking for the future of what's going to happen. And so I'll tell you what bionic means specifically to me in a second, but let's just all get in agreement that we need legal tech. This is not a commonly accepted principle, but I just want to make sure we're all on the same page that law firms are businesses, surprising, and the outsourcing or use of technology actually can help with client demands and actually make your practice more efficient. And I know we've talked a little bit about today too, but you can get really insightful data how to inform your business. So this is all makes a lot of sense to most people in the room here, but why aren't we doing it on a more regular basis? Because it's hard and because it takes away from the practice of doing law. When you have lawyers who are actually practicing, they don't have time or energy to actually implement new technologies. So I want to bring it back to focusing on why we do why lawyers practice law in general. And it's because they want to make their clients happy. They want to solve their clients' problems. So if we take it back to why we're doing what we're doing in the legal industry, it's because people have legal problems that they need solved. And if we go back to that core value, happy clients should equal profitable practice. So the idea is that you should really think about everything in the context of why are we doing this? Is it making our clients happy? And if clients are demanding technology, then you need to be seriously considering whether it's making them happy or not. So law firms are evolving. We have to use the word evolve multiple times here at Evolve Law. And traditional services firms in legal and other industries are starting to enhance their practice with technology to better serve clients. And this is happening in Big Four accounting firms. It's happening in other services industries. Legal is a little bit slower, but it's happening there too. So what I want to encourage us all to do is to be bionic and build bionic legal practices. And this is the example, the definition of bionic, if you can see it, which is having normal biological capacity enhanced by electronic devices, enhanced by technology. This is the cyborg, right? You're not machine. It's not where machines are going to take over the law. It's the cyborgs and the bionic beings are going to take over the law, which you're going to be half human, half machine. So you think of it like that. I want you to start thinking of legal practice like that and be bionic and build a bionic practice. And if you think of choosing technology in that framework, then I think it gives you a different context on how to make a selection. Your time is finite, technology is not. It makes you infinitely scalable if you use more technology. And there's a lot of ways to use more technology, but let's just get in that mindset where technology makes you scale and you cannot scale yourself. Most people in the room already know this, so I'm probably preaching to the choir, but in order to select technology with this framework, before you even look at new products, you should start looking at your own practice. What do you do? What time is wasted? Everyone knows when time is wasted. Everyone knows who hates doing certain things. You know if someone hates like filling in their timesheet or doing analysis of what went wrong on the client, or reading through documents and finding and replacing. I mean, how big of a waste of time is that? There's lots of things that you can pinpoint in your practice holistically before you even look at technology to say, this is not working, or these are things that could be enhanced by technology before you even know what's out there. And then you actually go to look for products. So this is how I would select a product. Once you know what your problems are, and you'd be amazed how many people start looking at technologies before they know what their actual problems are. Know what your problems are, and then know what the market is. Don't pick the first thing. A lot of, not all, but some law practice, they get excited about one thing they've heard in the news, and so they just want to use that product. But I always recommend that you take the time to look at the 5 products out there that are tackling the same issue. And you pick maybe the top 2 or 3 that you think are a good fit after doing your homework. I mean, this is a big decision. You're going to be interacting with the software on a regular basis. So actually do your homework, because it's a big decision and you should think of it like that. And then the top 1 or 2, test and trial before you actually buy it. And I think that's an underutilized thing. It takes time. It takes someone to actually go through it and give feedback, but it's definitely worth it. And then finally, make sure that the software is integrating, or whatever technology it is integrating with your existing workflows, and you don't have to change too much, that it actually can go along with what you're already doing and enhance what you're doing versus make you change entirely what you're doing. So once we know our problem, we find some technologies that we like and we've implemented it, commit to implementation. This is another challenge I see where someone will buy a product but then not actually dedicate the committed time and resources to make it work. And this is the tough part, and this is where a lot of things get lost. It's no good to anyone if you spend money on a software that doesn't actually get used. So having an executive sponsor always helps. And I'll give you one personal example. I used to work at Salesforce, and when I was there, they launched Chatter, which was their social media tool. And Mark Benioff was hounding everyone on a regular basis. Why are you not using Chatter? Put your photo up. Like, he would send direct messages to the youngest people at the company, and it freaked people out, and they got scared, and they used it. Right? I don't recommend taking that approach necessarily, but if you can have an executive sponsor who's really forcing people to use it in some way, it will get used in the polite way. But that helps. So either require usage or strongly recommend usage, or make it more difficult if you don't use it in some way. And this is maybe a little bit authoritarian, but it kind of takes this push to get especially something new and different through an organization that doesn't want to change. Lots of training and onboarding. This is another area where every software provider, every innovator will provide training and onboarding, but it's not utilized as much with everyone who's using the software. 1 or 2 people might do the training, but not everyone will always do it. Make sure everyone who's going to be using the software does the training. Have internal tech support. And then commit to a certain period of time to use the product before giving up, where you actually have some metrics and some analysis so you can see if it's actually working or not. So these are all the problems I see on a regular basis. And then lastly, continuous improvement. If something's not working, continue tweaking it. As software providers will always continue making their product better. You should always continue making your use of the product better and making sure that you're customizing it, you're tapping into the new features. If something's not working, you're talking with the provider of the software to make it better every time. It's not a single purchase and use. It's a relationship that you have to keep improving. So that's it. Make your law practice bionic. So thank you. I'll just say thank you again to Wolters Kluwer, who's our sponsor for this event. Thank you so much to the speakers who handled the challenges with technology very, very well. So an extra round of applause for them for that. So thank you so much. And please check out our Evolve Law website for the next events. So thank you very much, and enjoy the rest of your evening.